Welcome to Solving Citizen Legal Encounters. All right, today we're going to be in Judge Hunter's court where he has a pro se defendant that's a little upset about how things are going with his bond. Now, before we go into this, we're going to go ahead and look at his charges because this case has been going on since 2023. As you can see, there's a controlled substance charge, a weapons charge, 2 assault on police officer charges, and in the jail, furnishing contraband to prisoners. Now, what I gathered on his case is that there's been a lot of motions over time, motion to suppress different things. It's a whole bunch of different court dates that's been going on, which has led us up to this moment that you're about to look at now. And then you'll get more history of what happened recently when we go into the hearing. Also, before we go into the hearing, I want to welcome Elaine and Charlotte to the membership. Thank you for joining and check out the community post. Let's go.
3-6652.
For the record, this morning, Your Honor, Mike Roll on behalf of the people.
Something wrong with this.
Thank you, Your Honor. Richard Trush on behalf of Mr. Hillier, but it sounds like they might be having some technical difficulties in the jail.
Mr. Hillier, are you able to hear the court?
Yeah.
Joshua Jacob Hillier.
Yeah.
Welcome. So we're here today on a motion filed by the defense to reinstate bond. The court has had an opportunity to review the motion as well as the people's objection and response. The court exercises discretion today under 2.119E3 to dispense with oral argument. I'm very familiar with the background of this case and I'm ready to rule on the motion with the benefit of the motion response. The motion to reinstate bond is denied. There are many reasons for this decision, most importantly of which is Mr. Hillier, as you know, after protracted litigation and nearly 2 years of nothing happening in this case of substance, meaning I definitely had motion hearings, I had the relief of one attorney, I had the appointment of a new attorney, I had ultimately assigned Mr. Trush as stand-by counsel. Ultimately, I had Mr. Hillier, I'm not hearing from you. I'm making my ruling in the absence of oral argument, which I'm entitled to do. To the extent you make a claim or your attorney made an argument that it's not your fault you failed to appear for jury trial, which you did fail to appear for jury trial, I do not find any good cause for that failure to appear. You were arrested and lodged in a different county's jail because you purportedly violated the law in that county. That does not provide a sound or valid or good reason for you not appearing at your jury trial. What happened instead is
argument with my son.
Mr. Hillier, I'm going to go ahead and mute you because I'm not in need of your input and I'm not allowing it.
This judge is not to be played with, especially when defendants represent themselves.
In any event, as the court was indicating, what did happen is the prosecutor appeared with his witnesses ready for trial. It subpoenaed them for the trial that you demanded and requested. Your attorney appeared ready for trial. I appeared ready for trial. Law enforcement, as necessary for a trial, appeared and were ready for trial. The clerk's office appeared and was ready for trial. And multiple 30-some jurors appeared and were ready for trial. That trial was thwarted entirely because of your lack of appearance. That's not satisfactory to this court, especially not when in this matter, you have consistently demanded your right to have trial. You have rejected all plea offers at multiple final status conference plea cutoffs. You've had motions heard on merits on this case and denied. And ultimately, this case is in need of trial resolution.
It seemed like he's just on the edge of solving.
For your benefit, I've set trial to be resolved, and it will be resolved on June 30th and July 1st. That's the date of trial, and that's the date we're having it. So even to the extent that the attorney suggested to me, or I allowed you to be heard, which I'm not going to, that there was some plea offer that was anticipated by the people or by the defense, I would not permit it. We have many times been to the plea cutoff date. It has come and it has gone. And we're not going to have that. So the only way that the trial doesn't happen on June 30th and July 1st is if Mr. Trush contacts the court and tells me that you, Mr. Hillier, wish to issue a guilty plea as charged. Because I don't expect that, I'm simply keeping the trial dates on as they were stated. And we're going to have the jury ready, and you'll be ready as well. Mr. Trush, Mr. Roll, I view you as a prevailing party for the reasons I've indicated, but I also want to go through, before I have you prepare an order, a couple more issues, and that is with the background of this case, in order to, again, make sure it's clear why I'm denying any request to reinstate bond and why I'm keeping the trial date on. Again, this matter was bound over to this court on November 15th of 2023. We sit here 5 months away from 2 years on the circuit court docket. Defendant was represented by retained counsel, and at one point Again, that retained counsel changed. He had a different retained attorney who stood in for purposes of a motion hearing. I denied a motion that was filed by the defense, and ultimately then the attorney, Warren Wall, filed a motion to withdraw. That was not opposed by Mr. Hillier, and ultimately the court granted the motion to withdraw. That's when I had Mr. Hillier meet with Mr. Gilo to see if he would qualify for court-appointed counsel. At that time, he was arraigned. He was he was interviewed. It was that time determined that he did not qualify for court-appointed counsel. But Mr. Hillier also explained to me, and what I thought were no uncertain terms, that he did not want to represent himself. He was being essentially forced into that because he could not afford an attorney, and they did not deem him eligible for MIDC assistance. So I appointed standby counsel. I would also note that following the trial's cancellation, when Mr. Hillier failed to appear, I also recaptured and we went over with the attorneys my indications and my plan moving forward. And I want to make sure each attorney is fully aware of that. That is, I indicated that subsequent to Mr. Hillier being located, at the time we didn't know where he was, that I was going to order that he re-interview with the MIDC to find out if he qualified for court-appointed counsel, because my indication was going to be that bond would be revoked until the trial would be reset. So, Mr. Trush, do you know if Mr. Hillier has been re-interviewed from MIDC and whether or not he qualifies for court-appointed counsel now?
I can't speak to whether or not he's been re-interviewed, but I do know that I was given a notice of appointment.
Okay, so in any event, you understand you are the attorney appointed to him now, not a standby attorney, correct?
Correct. And I just identify that because at the point he became lodged, I don't know if Mr. Gilo would have re-interviewed him or just made the determination that he's eligible at that point.
Right. And either way, I accept that determination. Mr. Rolla, were you aware of that as well?
I was, thank you.
Then, Mr. Rolla, as the prevailing party, I just need to prepare an order that says, for the reasons stated on the record, the motion to reinstate bond is denied. Can you do that?
To sum it up in a nutshell, he put $500 down for his bond. He wants his bond back, but he didn't go to jury trial.
Very good. We'll do so. Thank you, Judge.
I'll hear from each of you in terms of readiness for trial, Mr. Trush, and I'll also let the attorneys make a formal record if they want in response to the court's decision today. So first, Mr. Rolla, did you wish to make a formal record in response to the court's decision on the motion to deny reinstatement of bond?
No, Your Honor, thank you.
Did you want to make a record on that point, Mr. Trush?
As far as the court's ruling, no, I think the court was clear. Obviously, we don't agree with it, but I think the court's ruling was clear. The one issue I did want to raise, though, the prosecutor attached a list, the list of the jurors to his response to the motion. I just wanted to address that to the court because I'm not sure we want that as part of the court's public record. The jurors didn't actually hear the case, but still, that's a list of potential jurors from the public potentially being made part of a public record. I don't know that we want that.
Well, the only reason I would question and ask what authority you would rely upon, Mr. Trush, is I generally understand, and I think you being sensitive to the jurors' information being out there is a good thing. And I suppose what I could ask the clerks to do is just simply redact the names or addresses. But the point that I wanted to make sure was clear is that you would have the opportunity on behalf of Mr. Hillier to examine the requested amounts and challenge them for accuracy if you wanted to, because as you know, when Mr. Hillier failed to appear, I ordered that he was going to pay the costs for those jurors. So if I had the clerk's office redact the names and phone numbers from whatever's filed in the clerk's office, would you still be able to reasonably calculate whether or not you think those are fair amounts that are charged?
Yes.
And is that what you're asking then? It's just to have the clerk's office redact names and addresses?
Yes.
Mr. Rowland, do you have an objection to that given the privacy concerns of the jury?
I do not, Judge, but again, for the reasons the court indicated, in case the defense tried to say these jurors weren't there, we needed the information showing that, in fact, they were there and their locations for mileage had been confirmed.
All right, and then from the clerk's standpoint, is there any difficulty in retrieving whatever's filed with the jurors' information in the court file and simply redacting that?
No, it just looks like Mr. Rolla attached a copy of the jury sheet that I provided the court the day of trial, and it just has a juror candidate ID number, which doesn't mean anything to anybody, and just their first name and then their per diem. It doesn't give phone numbers or addresses, it just gives them names, and it's attached to Mr. Rolla's objection, it looks like.
So I see that it has full names, though.
Yeah, if you would like me to, I have no problem going through and redacting the
Just
names.
redacting So let's do that.
Okay.
So the court will grant that relief. I think that makes sense. Mr. Trush, did you have anything else? Well, starting from the prosecution, Mr. Lola, are there other issues that the court needs to be aware of in anticipation of trial
No, Judge, thank you.
from the defense?
No, Your Honor, I will make arrangements with Mr. Hillier to get clothing for him prior to the trial. Otherwise, I think we're prepared to proceed.
So I hesitate to do this, Mr. Hillier. I've already made the decision that I'm making, but in the interest of fairness, I'm going to allow you to be heard. But I'm going to give you an opportunity to be heard only to the extent that you remain respectful, calm, and express demeanor that I would expect in a courtroom, because this is a courtroom. So if you maintain those things, I will allow you to be heard because I think it's fair given these circumstances. So I'm just hitting the button asking you to unmute. There's usually a button that jail staff can hit there, Mr. Hillier, if you want to hit that button, then you can be heard.
Okay, let's see how he acts now that the mic is open.
You need to also further understand, Mr. Hillier, that anything that you say on the court record could be used against you. It's in your best interest, therefore, not to talk about the charges or anything in the background of this case. Did you want to be heard?
Yeah, yep. My house is in foreclosure. There's no electric there. I'm sure the freezers are probably thawed out by now. Throw my $500 on my books, I guess. See you at court. $500 I posted for bond. Bail bond is to go, just to say I'm going to come back. I haven't gotten any trouble. I haven't ran from any court cases. I'm not some thug that runs around like your state police. I'm not like that. I'm a father of 4. I got 2 armed trained officers bust into my car and assault me when I'm going to get my son in Marquette. And then I get into it, destroys my family. And then the morning that I'm coming here for court for jury trial, I have 2 officers tell me I have a warrant that I didn't even know I had. It surprised me with a warrant and arrest me because I got into an argument with my son at a hotel, and I went and I'm time served. I'm time served on that. I pled guilty to a disorderly person and did my 90 days in jail up here in your jail. And I'm time served. The only thing I'm waiting on is you.
Well, they were waiting on you when they had the jury trial when you didn't make it.
I built this case that you have no idea if I'm guilty or not guilty on. And it's at my house. And I have nobody to bring it up to me or my lawyer. Both my fucking parents died the past 3 years.
That's it. Game over.
So the court's done hearing from you. When you start to use language like that, Mr. Hillier, you don't have a right to be heard when you're being disrespectful, and I explained that before you started to be heard. The difficulty with defendants who speak is sometimes they say more than they ought to, and that's why I caution you that anything you say on the open court record can be used against you. What you just told me in no uncertain terms is that you clearly violated the terms and conditions of your bond. But you did it in more than one way. One way was that you didn't appear for your jury trial, as I've already gone over. The second was, well, I told you that you allegedly had violated the law in other places. Now you've told me that you pled guilty to violating the law and served your time. That's an additional violation of bond. It's an additional reason why your bond is canceled and will remain canceled until your trial.
Pro se is not the way.
And so while the court would generally be sensitive to bond modification arguments in other cases, in this case has gone on for too long. I don't find any reasonable basis to continue bond discussions when we have a firm trial date set. And I'm confident that if you share your information that you have at your house with your attorney, you'll be able to get that information and properly submit it to the jury. This case should have been ready to submit to a jury months ago, but it wasn't. And it wasn't not because anyone else failed to appear, because you failed to appear. So again, the court understands your complaints, but I reject them. I ultimately find that trial is appropriately set and will continue on June 30th and July 1st. Court is in recess on this matter.
I'm not sure if his trial is going to be aired or not, but I'll see what I can do about getting it. But Judge Hunter is not a judge you want to play with. He is very strict. He runs his courtroom a certain way, and he's not going to take anything off of these defendants that want to represent themselves. In his court, you're definitely safe with going with an attorney. That's the best way to go. Now, I have a second hearing for you where this defendant was advised not to go pro se, but he said, hey, I understand the risk. I'm going pro se. So that's what he's doing. But I want to give you a warning. There's going to be sensitive information talked about with his case. So if there's any younger ones around, just have them go to another area or put your headphones in. It's not extremely bad. I'd rather that younger ears don't get to hear what the case is about. Okay? Thank you.
And gentleman at MDOC, what's your name, please?
Charles Douglas.
Thank you. This will be case 25-057974, State of Michigan versus Charles Anthony Douglas. Counsel.
Thank you, Magistrate. Steve Vincent for the people.
Judge, I think Mr. Douglas is in pro part today, representing himself.
Okay. Mr. Douglas, you do have a right to counsel. If you cannot afford counsel, the court will provide one for you. We have Mr. Reagan here. And I understand that you want to move forward without counsel. Is that correct?
Well, I asked for counsel's assistance, but I would like to represent myself.
Judge, we did go over everything with Mr. Douglas, Judge. He listened, we talked to him, and went over everything, and he just wants to represent himself, Judge. So we are here.
Okay, sounds good. All right, sir. If at any time you want Mr. Reagan's further input, just let us know. And
Yes.
Did you go over the charges with him, Mr.
Yes,
Reagan?
Yeah, Ms. Chive went over everything, Judge.
Okay, sounds good. Court will enter a not guilty plea on the client's behalf. Esteban.
Magistrate, as you can see, this defendant's being charged with those 2 CSC first, both life offenses. We're not going to object to a personal bond here. We don't think under the pre-trial it would be necessary to give him a cash bond. He's not a flight risk. He's not a danger. His earliest release date from the MDOC is 2038. He was previously convicted of a CSC first, a CSC third. He also has a 2005 juvenile adjudication for aggravated assault. He has an 2008 armed robbery juvenile adjudication. He ended up pleading to drugs in school 2011. In 2014, he ended up getting an attempt felony delivery manufacture controlled substance less than 50 felony firearm. And I understand this isn't on the HAB, Magistrate, but I have more information regarding this defendant. In 2012, he ended up pleading to a home invasion second degree. Actually got cited there, but that was revoked. Then he ended up pleading to this CSC first and third, A and B, as well as an unarmed robbery. He ended up getting 40 to 90 on the CSC first. He got 10 to 15 on the CSC third, as well as 10 to 15 on the unarmed robbery.
Warning.
And here we have a defendant who allegedly ended up setting up a gang rape of a complainant, where there were at least 6 people based on the investigation that participated in this rape of the complainant that the defendant ended up setting up. He's been ID'd as the offender, and his DNA was also picked up on that buccal swab. So for all of those reasons, Magistrate, I believe under 6.106 MCR, the court can give cash if it feels as though this defendant is a danger and or a flight risk. The people don't see him being either. So respectfully, we're not going to be objecting to a personal bond here.
The reason for that is because he's not getting out of jail anytime soon, so they don't have to worry about him going anywhere.
What's his early out date?
2038.
Okay. All right. Based on everything the people put on the record, I would ordinarily, in a case of this nature, have a very high cash bond, but given the fact that defendant is in MDOC for at least the next 13 years, it sounds like, court will set bond at $50,000, 50,000 personal. Next court date will be June 30th. I'm sorry, did you want to add something, sir?
Yeah, I would like to respond to the false statements that the prosecution has made.
Okay, feel free.
First and foremost, Your Honor, happy Father's Day.
Huh?
Okay,
Same to you.
well, I want to first bring up that this case occurred allegedly in 2013, where the state, the people's office had no due diligence in investigating this case at all.
Okay.
There was no allegation. I've never been convicted of being a gang member. That's a false statement.
This is why pro se doesn't work. They didn't say he was convicted because he was in a gang. It was the act of something else that you can look up is what he participated in as a gang.
Okay.
MDOC has accused Kim Worthy and the Wayne County Prosecution's Office of attempting to smuggle me drugs. I have documentation of MDOC accusing Wayne County's prosecution office of smuggling drugs to this facility. It's under investigation right now. I want to make clear that no investigation whatsoever has been conducted into these allegations since 2013. This complainant knew my name. I was a willing cooperative. I cooperated fully with this investigation. Once it became brought to my attention during my trial of an unrelated offense, I had no opportunity to investigate the warrant, the complaint. I have no opportunity to investigate any of the alleged statements that the prosecution has made. And based on Michigan court rules, I still have opportunity to investigate, locate, contact, interview, and produce potential evidence that's exculpatory.
Okay.
I want to make this clear also, Your Honor, that I appreciate this time that you allow me speaking, but my life is on the line, not been railroaded. It's an innocent man, an absolutely innocent man, right now on the case that I stand trial for. A federal district court has just ruled that I have newly discovered impeachment evidence. And now MDOC and now Wayne County Prosecutor's Office decides they want to pursue charges on the 13-year-old case because the judge has just ruled that I have newly discovered impeachment evidence.
Okay.
So I would like for the record to be clear that I would need time to investigate the warrant and the complaint because I had no notice of this. I've just been notified today. I couldn't even brush my teeth today. I was rushed to this meeting. So I would like this to be transcribed. I want the transcripts from this meeting too, because I need an opportunity to go to the Court of Appeals and appeal your ruling, because I feel like this is a malicious prosecution at this point. It's a selective prosecution. So thank you, Your Honor.
All right. Thank you. And so obviously today is just the arraignment on this matter. You'll have every opportunity to obtain discovery and get transcripts and all of that as the case proceeds. Court is going to set bond at $50,000 personal, no weapons, no contact with the complaining witness. And next court dates are June 30th, probable cause conference, and July 7th, preliminary exam, both in front of Judge Jakay, and Judge Jakay can address all the issues that you just raised.
Will I be in person?
I don't know. Probably probable cause conference will probably be Zoom, and they'll have to writ you out for the exam to be in person.
Okay. Well, is there any ruling that you could make? Because I really need to be in person representing myself.
I don't believe probable cause conference, they're going to want you in person. They're still doing those by Zoom. But it will give you an opportunity to raise all of the concerns you raised this morning with Judge Jakay, and he can address all of those.
Okay.
All right, sounds good. Thank you, sir. You're all set for today.
All right, thank you.
Well, as you heard, everything is being talked about except the current case. Also, the situation that came up with the CSC charge, he's definitely not making no comments on that. So he's going to a courtroom that I'm probably not going to be able to get the hearing again, but I'll look. But if I can, I'll follow up. If I can't, it's just a pro se for us to look at. So I hope you enjoy both videos, and I'll see you around on the next one.